What happens if the people who are in my estate plan, my will or my trust, what happens if they die before me? This is actually a problem that happens more than you'd think. People create an estate plan, they create a will document that goes through probate, or they create a irrevocable trust which avoids probate, and they never update it. And during their lives, things happen. Either relationships fall out or people lose contact, but also sometimes the people in the document have passed away prior to the person who created the trust or the will dying. My name is Philip Bruce. I'm an estate planning attorney here in Minnesota. And first off, when you're drafting these, if you're working with a professional, the professional is going to, if not insist, at least strongly recommend that you have a number of backups. I talk about how it's almost a waterfall when it comes to who gets what. We always say this person gets it, and if this person doesn't get it, it's this person, then this person, then this person. If you no longer own this property, then this is what happens. And we want to think all that through very carefully. But nonetheless, sometimes those things don't work out. If we're talking about the person who's supposed to get property has passed away, well, hopefully there's some backups that we've planned there. If not, we want to see what the statutes say. So there is a backup rule. When the will doesn't control something or the revocable trust doesn't control something, our backups are always going to be the statute. And the statute is going to spell that out. It's almost certainly going to go to a family member of some sort, although you won't get to choose that. So that's what happens if the person receiving the money or the real estate or the other property were to pass away before the person who created the document, before you. The other aspect of this, though, is we've also appointed some people to be in charge. There's certain rules. There's guardians of minor children, but there's also just the executor or the personal representative of the estate. And maybe if we're hanging on to the money for someone for a period of time, we have a trustee. We always want to have our backups. We have to be very specific about if this person is unable or unwilling to serve, then this person. If we have co-trustees, co-executors, so there's multiple people working at the same time, we got to be specific. If one can't act, can the other act independently, or are they both not able to act? That becomes a problem in probate pretty regularly when that's not spelled out. So ideally you have your backups, and if you don't have your backups, well, guess what? We have statutes, and the statutes create a priority of who's next. We want to make sure we have these backups in your documents. If you have documents of your own, review them to make sure that that's all set for you. If you don't, and you're meeting with an estate planning attorney, make sure you do have your backups for all this created, because it's your option and you have the ability to do this, and we want to make sure you're able to. Any questions about this, give me an email.